Thank you everyone for joining today to hear all about Pennsylvania's wonderful right to know law. It's an important law for all sorts of different people, attorneys, citizens, activists, stakeholders, media. It's an important thing, and we're lucky to have it in Pennsylvania as something we can use to hold governments transparent and accountable. So this became a venture when I had spoken to the executive director of Pennsylvania Office of Open Record of Pennsylvania ACLU. Right. And one thing that we always want to do is try to reach out to requesters. We have regular webinars talking to agencies, how they deal with right to know requests, but reaching requesters is something we strive to do whenever we can, so that people understand what a great tool it is. So it's been great to work with the ACLU in putting this together. I've been working with Jessica Lee and Andrew Christie, and they will be joining me in presenting this. And I also have on standby two of my colleagues in case there get to be some really technical questions. I may ask them to unmute themselves and assist if things get kind of in the weeds. So let's get started. Here's a quick sense of the agenda. We're going to go over the background, history and background of the law, talk about some basics of it, then go through how to file a request, how to file an appeal if you're unhappy with your request, then go over some things that we've learned throughout the years we've been dealing with appeals and understanding the law. We'll go over some tips and best practices and also have questions. And like we said, you're welcome to put questions in the chat throughout, and we'll try to address it if it's something that makes sense at that time. If not, we can try to address it at the end, or you can email us separately. We can talk about it that way. So history
Liz,
and yes.
I'm sorry to interject already. Could we just do some quick introductions
I apologize.
of who we are?
Yes. Yes, I apologize. All right. Andrew, why don't you introduce yourself?
Well, actually, do you want to introduce yourself? And
okay.
I don't think you actually said who you are.
Okay, I'm Liz Wagenseller. I'm the executive director of the Pennsylvania Office of Open Records. I was appointed by the governor last January to take this position. So it's been about a year and a half. And before that, I worked for the Department of the Auditor General, so a different government accountability agency. And it's been a wonderful experience thus far. I've learned a lot. We have a fantastic team, many of who are joining today, and I look forward to talking to everybody.
Thanks. And so my name is Andrew Christie. I'm one of the attorneys at the ACLU of Pennsylvania. I've been here for about 6 years, and although a lot of my work focuses on criminal justice issues, I've also fallen into a bit of a niche doing a good amount of government transparency, open records work, several right to know law cases in the pipeline right now. As you may imagine, the ACLU submits a lot of right to know law requests. So this is a topic that is near and dear to our hearts, not only from the lawyer perspective, but also in our sort of investigatory and advocacy perspective. So let me throw it over to Jess to talk about her role.
Hi, everyone. My name is Jess. I'm a criminal justice policy associate at the ACLU of Pennsylvania. I'm based in our Philly office, and I've been at the ACLU for almost 3 years. I'm housed in our advocacy and policy department, and also regularly use the right to know law for advocacy and holding our elected officials accountable and keeping our government transparent. So really looking forward to sharing some of the tips and best practices that we've gleaned in our extensive experience with the right to know law. So I will throw it back to Liz.
But it sounded like someone was calling Jess's house at just the right moment.
All right, thank you. All right, so history and background. The right to know law. So before 2008, if you wanted to get records from a government agency, the situation was you as the requester had to prove why you should have access to that record, why it should be public. That was quite an arduous task for your average layperson. You have to understand law, you have to understand the lingo. And so under the leadership of former Senator Dominic Pileggi, Pennsylvania legislature decided to change that. They thought that it was too much of a burden on the average person to do that, and that the government should be more open to individuals trying to see records. So they just changed this Act 3 of 2008. It was a complete rewrite, and they changed it so the presumption flips. Instead of the requester having to prove why they should have access to a record, then now the agency has to prove why they should not have access to those records. So that was a huge change, and it really opened the door to a lot more people accessing records. In terms of, like I said, all public records are presumed public. And this includes local agencies, your local government, your school district, police departments, all of those, and the Commonwealth. Most things you think about, departments, boards, the Auditor General, Treasurer, Attorney General, community colleges, all of those entities are subject to the right to know law. Let's see here. So a few records are available. There are some exemptions. So when you look at judicial, basically the judicial branch is the courts. It's basically just financial records that are available. State-related universities, the 4 state-related, Penn State, Pitt, Lincoln, and Temple. They have significantly less that's accessible. They are exempt except for they have to provide some reports every year, an IRS form, some salaries of some of the top ranking officials. So basically that type of information from those schools. And the legislative agencies, you can access legislative records. So things that have to do with their basic legislative work. This does not include emails. So emails from legislative members or employees are not subject to the right to know law. Now I want to talk about the history of the Office of Open Records a little bit. So this is one of the best things about the 2008 revamp, in my opinion. Before, if you submitted a request to an agency and you were denied those records and you think that you were unfairly denied, your only option was to go to the courts, which is expensive, it's intimidating, it takes forever. So one of the best things about the overhaul of the right to know law was the creation of the Office of Open Records. It provides a way for, a simple way for anyone to appeal a denial of a record to an agency. We'll talk about it more later, but it's a very simple form. It's something that anyone can do. And again, during the appeal process, the burden is on the agency, not the individual, to say why the records should be accessed. We provide training on the right to know law, and we also provide a training on the Sunshine Act, which is the open meetings law in Pennsylvania. We have about 22 people on our staff, including 15 attorneys and 5 administrative individuals. And all right, so next, I want to talk about what's been going on in the world of right to know law. So we only see the appeals, and that is about 3% of right to know law requests are appealed. And there has been a huge increase in appeals, and I imagine this is very much mirrored in the agencies if you ask them about their right to know law requests. And as you see, 48% increase in 5 years in Pennsylvania. Just a remarkable increase. And as you will see, the line for funding does not have a remarkable increase. So that is something that we deal with and have to talk about as we consider how appeals are processed here. I want to talk a little bit about where we're seeing some of the increases. And COVID turned a lot of things on its head, and our office is no exception. The government was in people's faces more than ever had been before, and so we had huge increases in the Department of Health, wanting to understand COVID data, huge increases in school districts, because I'll talk about that later, state police, because a lot of the police reform issues going on, and then Department of State, because of a lot of the election-related questions people had. Locally, on the next slide, you'll see that local governments had huge spikes. Again, counties, which deal with a lot of election-related issues, had big increases. School districts continues to be one where people want to understand, even after COVID, things kind of died down, things related to content taught at schools, and then local governments also felt a big increase. Now I'm going to turn it over to Andrew, who's going to talk about some of the basics of the law.
Liz, there's a question about whether OR, I guess, ever does or could file a lawsuit against an agency. And I assume that I'm just going to editorialize and assume that the question is aimed at, like, let's say there's an agency that is doing a really bad job of complying with the right to know law. Does OR even have the legal authority to do that, if assuming that you had, the capacity?
We can find that they acted in bad faith, but there isn't necessarily ramifications of that. The courts can, if an agency has acted in bad faith, can fine them. And there have been some cases, one recently, where an agency was fined over $100,000 for that.
Yeah. Okay. Thank you, Liz.
Mm-hmm.
Yeah. Okay. So now that you have a sense of a little bit of the background, I'm going to talk for a bit about what exactly you can access. So the definition of record is really at the heart of the right to know law, because the right to know law allows you to access records. It's a term that is pretty broadly defined to basically encompass any information that an agency possesses, something that covers whatever it's doing in the course of its business. The definition's up on the slide. I'm sure you can read this and other fun slides to yourself. But it really is intended to broadly cover whatever format and whatever type of records the agency might have in its possession. So everything from memos to emails to text messages are all fair game under the right to know law. Other thing I want to mention specifically is about databases, because a lot of information, of course, is stored in databases these days. Whether that's a fancy Oracle database or maybe something that's a little more straightforward, like complicated Excel spreadsheets. Liz and Jess are both going to talk about databases in more depth later in the program. But I just want to flag for you that you definitely can get information from databases. The ACLU regularly gets printouts, data thrown into Excel spreadsheets, et cetera. For example, we often send requests trying to track how many people are being incarcerated in local jails. And so we'll just get a printout from the jail database of who was put in on the specific date. When it comes to records, though, the agency does not have to create any records. They only have to give you records that already exist. So this is really important to consider when you're putting a request together, because you can't ask the agency to create something for you. This often comes up if you are asking for a list of something. Agencies don't always have lists of things, even if you think that they should. And so if you ask for a list of everyone who falls into XYZ category, but the agency doesn't have that list, then your request will be denied, and rightly so, because they don't have to create anything for you. So when Jess goes over some best practices, one of the things to keep this in mind, and one of the things that she'll probably talk about is how to structure your requests to get around these barriers. Like, for example, you can't ask for a list, but you could ask for records that would allow you to compile your own list. There also are lots of exemptions to the right to know law. I mean, in theory, and by default, every record is presumed to be public. That's the big change that goes along with the right to know law as compared to its predecessor. But there are numerous exemptions that government agencies can use that are in the right to know law that allow them to withhold records. So there are 30 exemptions dealing with a range of issues from public safety to trade secrets. Now, in theory, these exemptions are discretionary for agencies, which means that, maybe the public safety exemption applies and an agency could withhold it. But if the agency is favoring transparency, they could still give the record to you. The only exceptions to that discretion, I suppose, are if there's a law like HIPAA or FERPA or something where there's actually a separate statute that says that it can't be released under any circumstances. But if we're talking about the 30 exemptions within the right to know law, there is some flexibility for agencies. Unfortunately, I'll say that in the ACLU's experience, agencies usually are happy to claim whatever exemptions they can and don't exercise that discretion in a way that favors public transparency. So don't necessarily get your hopes up, but there's always the possibility that you can convince the agency not to use an exemption. the last thing on this is the issue of redactions. If part of a record is exempt and withheld, then, but the rest of the record is public, then what is supposed to happen is the agency is supposed to redact, black out the information that is not supposed to be released, and then release the rest of the record. Sometimes agencies forget about this and forget that that's a legal requirement. So it's something that, you can point out if you're facing having a records request denied. It's also something that's useful to point out on appeal if if you get up to the Office of Open Records level, to say that, oh, well, sure, they've said that some of this information is subject to an exemption, but they didn't give me the portion that should be public. We're not going to go through all 30 exemptions, thankfully. The Office of Open Records flagged here for the top 5 in terms of the number of requests, the number of appeals that they receive based on specific exemptions. The ACLU, because we do a lot of our right to know laws requests are in the criminal justice realm, doesn't necessarily deal with some of these exemptions. Our top 5 would be slightly different. Public safety of buildings or infrastructure, criminal investigation things. Those are really the exemptions that often come up for us. But what's worth understanding is that whatever type of requests you're going to be doing regularly, there are probably some exemptions that are more likely to come up than others, and it's useful. Maybe you'll get some information through this presentation, or perhaps by doing some research on your own, to familiarize yourself with those exemptions and think about then, okay, well, if these are the problems I'm likely to run into, how can I structure my right to know request in a way that avoids those issues? So I'm going to talk about some of these 5 as they relate to ACLU work and things that I actually know about. And then Liz is going to cover a couple other ones. So starting with the criminal investigation exemption, this is a big and broad exemption that regularly gets in the way of the ACLU trying to figure out what's actually going on with law enforcement agencies and in the criminal justice world. It covers anything relating to or resulting in an investigation, except for the filing of public charges. A very broad language relating to or resulting in. Pennsylvania actually, as I understand it, has one of the most expansive criminal investigation exemptions of any state in the country, which means as a consequence that it's really takes a hit on public transparency and makes it more difficult to obtain records from law enforcement agencies and try to understand what the police and what district attorneys are up to. It's a real problem. I mean, there's just from the ACLU's perspective, perhaps not a problem from the district attorney's perspective. So you have to be careful about how you can target your requests. There is some information that clearly is available. So police blotters, private criminal complaints, and what a private criminal complaint is not like a complaint to the police to go investigate something. It's someone who is trying to initiate a prosecution and is asking the DA to do it. It's sort of a niche and sort of strange thing in Pennsylvania. Generally, training and policy materials would be fair game under this exemption, although as I'll tell you in a minute, sometimes then you can run into other exemptions. So if you ask for something that is more generic, that isn't tied to a specific investigation, that doesn't include information about a specific investigation, that might be some information that is viable to get from a law enforcement agency. The other fun thing about this is that appeals from the denial of a records request based on this criminal investigation exemption do not go to the Office of Open Records. They go to the district attorney's office for that county. So if you're requesting records from a police department, and they say, no, that's a criminal investigation and you want to have an appeal, it goes to the DA's office. If you send a records request to the DA's office and the DA's office says, no, this is investigation material, you appeal it to that same DA's office. From the ACLU perspective, it seems like a bit of a conflict. We don't have a great win record in those circumstances, but it's important to know where your appeal should go and how it's going to be adjudicated. And Liz is going to talk about this later in the appeals section as well. Okay, so the last thing I wanted to say here is that since we're on the topic of criminal justice, even though it's not directly related to that exemption I was just talking about, recordings of things like body cameras or dash cams are not covered by the right to know law. So for police video and audio recordings, there's a separate law as of 5 years ago that covers that. I will say that it essentially makes it impossible, practically speaking, to get copies of those recordings. So just keep that in mind, and don't waste your time sending right to know law requests for those sorts of recordings. The last exemption I'm going to talk about before it goes to Liz is the public safety exemption. So based on the text, one would not necessarily think that police department procedures, for example, would fall under this exemption. But when I said that if you're asking for, say, policies and procedures from a department, that may not be caught up under the criminal investigation, but it might be caught up under a different exemption. This is one that we found actually can be a real hurdle there as well. So I'll illustrate with an example. We have a case that's actually currently in the Pennsylvania Supreme Court for the second time. It's a 5-year-old piece of litigation where we're seeking from the Pennsylvania State Police the administrative policy that governs their internal procedures for how they spy on people's social media accounts. And so what the argument from the state police is that there's a threat to public safety if they provide this record and information, because basically criminals will be able to avoid surveillance and public safety will be threatened as a result. In that particular case, we disagree with the conclusions. That's sort of irrelevant, but I'm just using that as a way to highlight that some of these, if you're asking for policies or procedures, some of these exemptions can easily overlap. Another context this often comes up in is the prison context. If someone's asking for information about conditions or anything about prison facilities, they're very concerned that the agencies are very concerned that someone's going to figure out how to endanger the safety of the people who are incarcerated there, or do a jailbreak, or the imagination knows no bounds. Okay, so I will throw it over to Liz.
Great. All right. Now I'm going to talk about non-criminal investigative exemption. This is similar to what Andrew explained about criminal. It's very, very broad. Basically, if an agency is doing an investigation that is not criminal in nature, the materials, notes, all the things that are used in the process of investigation are exempt, not the final action. So some examples of non-criminal investigations. They can be disciplinary actions taken against employees at the agency. So you can't see all the paperwork and the accusations being made, but if they are terminated or fined, you can see that final document, but not the investigative materials into that disciplinary investigation. Things like use of force at correctional facilities. That is not a criminal. If it's not a criminal investigation, they can use that. This is an exemption as well, unless there is some final termination for the individual accused of the use of force. If there's an incident at a school board meeting or any other kind of public event, again, those can be withheld. And audits. So the final audit report is allowed to be, is publicly available, but the underlying work papers under an audit are not. And so as it says, executed settle agreements, fines and penalties, or other final actions are allowed, but not the other investigative records. Next is internal pre-decisional. So this is a really interesting one. When they wrote the law, the thought was, I think wisely, that employees at an agency are allowed to think out loud, play devil's advocate, throw an idea out, have deliberations with their colleagues and others in government to talk about what is the best approach to take on this? Here's a draft of a news release. What do you think? That allowing that free thought without the concern that someone's idea could be accessed and used against them in some way is an important part of a functioning operation. So this exception talks about basically those three words. It must be internal, which I'm going to talk about a little bit more. It must be among employees or other government employees. It must be prior to decision. Talking about what a decision that already happened is not pre-decisional, and it must be deliberative. You must be going back and forth and talking about things. One thing to note that Andrew mentioned, that if there is an email where, let's say people are going back and forth talking about a draft of a news release, their deliberations can be withheld, but in that case, if there's some factual information, like here's the data that we're going to talk about, that should not be exempt. So in that case, the agency can redact all those things, talk about the deliberation, but the factual information cannot be withheld. So that's an important thing. Budget and legislative strategies are an example about this. Now, a big case that happened last year is the courts decided that it must truly be internal. They must be government employees on the communications or exchanging this record. If you copy, as in this case, a consultant or a subcontractor, it is no longer internal. It is outside consultants. And this has real ramifications in Pennsylvania, and there's talks of perhaps changing it, but at least for now, that is not considered internal. And the next one I want to talk about is personal identification information. Obviously, you don't want your driver's license number, your social security number, your personal bank account numbers. You don't want those being part of a public record. So those are clearly exempt. Telephone, phone, and then one that we do see a lot is, for whatever reason, a record contains the personal phone number or personal email address of a government employee. Unless that's something that you use publicly and you advertise it, those can be exempt as well. Some personal information, these are typically for employees, marital status, spouse's name, those things are considered personal identification information. A couple of things that are not considered personal identification information are your job title and your wages. And again, this is a case where this typically involves redactions, not complete exemption. It's if a record that is publicly available contains this information, it may be redacted. And the last one I wanted to mention is personal security exemption. This is about someone's personal security, clearly. If an agency has to prove this, they must prove that there's a reasonable likelihood that there could be a substantial and demonstrable risk to someone's personal security. This is something that we see sometimes agencies try to use, and it doesn't always, they don't need to prove it. They just can't say, hey, this is going to be something that threatens somebody. They have to prove it and explain why, and sometimes agencies fail to do that. The example here is someone wanted some locations of some shot spotter information, which could show perhaps where some of these shot spotter, these audio things pick up the sound of gunfire, and some individuals allow those to be on their property. And perhaps if someone knew that they were allowed to have those on their property, then they would be targeted. So that's one example of that. Let me see a question. Let's see here. So home addresses of public employees other than judges and police can be obtained. Actually, there was a very specific case that talked about that. Kyle or Nathan, can you chime in about that, please?
Sure. There was a Supreme Court case involving PSEA, where the Supreme Court reiterated that home addresses are personal information that's subject to the right to privacy. And as a result, it means home addresses are generally not able to be obtained under the right to know law. For the Office of Open Records purposes, we're supposed to weigh the public interest in releasing those addresses against the privacy interest of the people the individuals implicated. And the court's made clear, for the most part, that means that home addresses are off the table.
And that can seem counter to what you can pretty easily obtain via Google, but regardless, that's what the courts have said. With that, I am going to turn it over to Andrew.
Yeah, thanks, Liz, and thank you, Kyle. The Office of Open Records rolls deep, and came in here with a whole crew to make sure that all of your questions can be answered. Please don't overwhelm us with questions, but no matter how technical, Kyle, et cetera, can handle it. All right, so now, in theory, now you should have an idea of the general types of things you can get through the right to know law, as well as an idea of some of the barriers you'll run into in terms of the exemptions. So we're going to switch over to talking about mechanics. First by talking about how to actually file a right to know law request, and then Liz is going to handle appeals after that. Step one, figure out where you need to send your right to know law request. You can't just fire it off into the ether and hope for the best. You need to identify which agency you're sending it to. And again, an agency, it's a technical term. It's a term of art in the statute, but agency can mean your township. Or it can mean the Department of Corrections, or any sort of government entity, whether state or local. The Office of Open Records has a very handy search feature on its website that allows you to look for the right to know law officers for each agency in the state. The agencies send their info to the OOR, gets put on the website. I will warn you that in my experience, this information is not always current, because it's not a problem of OOR. It's the problem that the agencies might have staff turnover, different email address changes, et cetera. And so we'll not always update OOR when those things happen. Just a couple of weeks ago, in my free time, unrelated to my ACLU duties, I sent out 60 right to know law requests to every township in Montgomery County asking about specific information. And I used this feature, and for example, there were a couple of township name at Comcast.net, and some of those were legitimate, and some of them ended up being bad addresses. So you may need to do some cross-referencing when you are trying to figure out where to send your requests. Some agencies, like a county or a city, might have multiple right to know law officers for different areas that they handle. So like the district attorney or the sheriff might have separate right to know law officers. So again, it's just important of nailing down who you should be sending your request to based on what you're trying to achieve. There's a standardized form, which I'm going to go through in a second, that is put out by the Office of Open Records. So don't feel like you need to use whatever customized form you might stumble across on the agency's website. Some of those forms actually ask for information that I think is inappropriate. OOR's form has to be accepted by every agency. So we, at the ACLU, we always just use the OOR's form, never run into any issues with it. When you're filling that out, as Liz bolded, underlined, and made red here, be specific when you're making your request. Jess will get into some of this in her tips, but if specificity about the subject matter, about whatever date ranges you have in mind, if you have a sense of what type of records they are, maybe it's something in a database, maybe it's a spreadsheet, whatever. If you're talking about emails and can figure out who the likely sender and recipients are, all these are going to make your life a lot easier, because it's going to help the appeals officer, the right to know law officer for these agencies does not know everything that goes on in the agency. So they actually have to ask around and do some searching. And so specificity helps them, help you. And then when you get up on appeal, you avoid, if it comes to that, you avoid problems of having such a vague request that OOR or the court says you got to try to be more specific. So on the form, not rocket science. Put the agency name, fill out your own information, your contact information, which is actually important because I've had right to know law officers contact me to discuss requests, help try to work it out, figure out the best way to approach it. Below that, you fill out the information, putting explaining what records you're requesting. Again, with that specificity we described. And for lengthy requests, I'll often say see attached and attach a page. Then you want to explain how you want copies. Electronic copies are free and generally easier and more convenient to get. So go the electronic route if possible. And then the rest of it just gets filled out by the agency. So again, very simple. OR has done a stand-up job of trying to make it as straightforward as possible. Things get a lot more complicated after you submit the request, ironically, because then you have to start watching the calendar and track deadlines. And some of the deadlines are based on business days and other deadlines are based on calendar days. So it can really mess with your mind, and you need to be careful about this. The agency has 5 business days to respond to your request. And the agencies can also take up to, it can take one 30-day extension. That 30-day extension is 30 calendar days. So 5 business days to respond and a 30 calendar day extension. It's just the reality that agencies often will take that 30-day extension. So just plan that you're probably not going to get the records within 5 business days. Probably the agency is going to take the extra month. You and the agency can agree to different deadlines. If you end up in negotiations with the agency, just make sure you're putting everything in writing. If you have a phone conversation with someone, follow up with an email and document what you've agreed to. When deadlines get moved around, you really are at risk of losing your appellate rights if you end up not getting everything you're looking for and you need to take an appeal. So just please be careful and try to protect yourself. So here's an example of, I'm sorry, getting ahead of myself. The right to know law does not really, in my view at least, the right to know law doesn't really do a great job of explaining what's supposed to happen. If an agency just simply can't produce all of the records within 30 days, it's going to take longer to go through all these emails and find responsive emails, something like that. In our experience, what we usually do is try to negotiate some sort of rolling production schedule where we'll give the agency additional time and come to an agreement about how long it's going to take them to do things and set specific deadlines. But sometimes, as you'll see in a moment, you may need to protect your appellate rights by filing an appeal, even before the production is complete. I mean, it's amorphous in my mind. And so what I would just generally suggest is making sure you have everything in writing and doing everything you can to make sure that you're keeping track of which days are counting towards those deadlines and which days are not, so that you're not missing any of those deadlines. Okay, so here's an example of someone who thought they were doing the right thing and working with the agency only to end up losing on appeal because of the strict deadlines in the right to know law. So request was made on August 1st. Agency gets back, takes a 30-day extension. Okay. The 30 days runs on a Saturday and the weekend days don't count. So it kicks over to Monday. A couple days later, agency says, well, we need some more time. But because they didn't respond on Monday, it turns out, as the requester later found out, that the agency's response asking for 30 more days was untimely, which means that really the appeals deadline started ticking on that Monday that the agency did not respond. So the major takeaway is that these deadlines are strict, and you just need to be careful. And again, like in this situation, if what should have been done in hindsight is that the person should have filed an appeal based on the September 9th deadline. And I just wanted to say that, don't be afraid about filing an appeal. We often at the ACLU will file an appeal, which, as Liz will show you, is a very easy form to fill out online. It's nothing to be stressed about. We often will file an appeal and then continue negotiations even after filing an appeal. So we'll file an appeal. We'll ask the Office of Open Records to stay the appeal while we continue to work with the agency to produce records. It's annoying sometimes that we have to do that, but it's just a way. It's an approach that we take so that if So we're not blowing any deadlines in terms of our appeals. And also it is actually helpful sometimes in negotiations with the agency, because then, they know you're serious. Their lawyers will get involved. The right to know law officer is not necessarily a lawyer, but there's usually a lawyer that gets involved at the appeal stage, and can just sort of help move things along, because no one wants to litigate this stuff if they can avoid it. The agencies, sometimes they are really digging in their heels, and that's one thing. But often are happy to sort of help work it out. All right, two other quick things before getting it back to Liz. The fees. So the Office of under the Right to Know Law, the Office of Open Records sets the fees, and thankfully we have a really wonderful Office of Open Records that is not hammering us all with unreasonable fees. Sometimes I've seen some individual agencies that purport to have their own fee schedule that is completely different and higher than the Office of Open Records fee schedule. That's illegal. They can't actually charge you those fees. You just stick with what the Office of Open Records has. You can look on their website. And again, there's no charge for electronic records, which is wonderful and a great reason to search, a great reason to ask for those electronic records. All right, and then the last thing I will say before it goes on to appeals is talking about the agency response and denials. So, I've talked a bit about negotiating with agencies, working with agencies to give them more time and try to, kumbaya, all get along. Inevitably, you're going to have some requests denied, in part or in full. There really are two types of denials. So one denial is when the agency sends you a letter, which is what they're supposed to do, email or in the mail, that says, we're denying it. These are the records we're withholding, and these are the reasons why we're withholding them, and here's information about how to file an appeal. The other type of a denial is a deemed denial. Again, very important to know from a deadline perspective. So this is when an agency is supposed to respond by a specific deadline, but does not respond by that deadline. And so, if the response is due on Monday, then Tuesday is day one of it having been denied, and your appellate clock is ticking. So you need to keep track of the calendar and keep track of when things are deemed denied. Okay, hopefully there was a lot there. I hope that made sense. And I think it goes to Liz now. Liz, you're muted.
Kyle has been answering some really good questions in the chat, and I just want to mention one that is important to understand. It does not matter which device or which account a public official uses to communicate about agency business. If they want to use their Gmail or their personal phone, if they're talking about agency business, it's subject to the right to know law. It's best for them not to do that, but if they choose to, for whatever reason, that does not mean that they're avoiding the law. There was, I think, Missouri, a governor came in and they tried to do that, like, let's just do everything on Gmail, then they don't have access to our emails, and the courts there said no. And the courts in other ways have said that here, that even if it's Facebook Messenger, all of that is subject if you're talking about government business. Okay, so I'm going to talk about the appeal of a denial. So you've made a request, you've been denied access in part or whole, or you've been denied access via redactions, and you would feel that you were unjustly denied. One of the great things about the 2008 overhaul of the law is you can appeal that, and it's very simple. The timeline is important. You have to do it within 15 business days of mailing the day of denial. Most of them go to us, but if it's an agency that's outside of our world, then they have their own appeals officers. And as I mentioned, you can also appeal the redactions and the fees, which happen sometimes. All right, so next slide. And what it's like. So we're going to talk about the form, but the idea is for it to be simple. It is not meant that you need to have any knowledge of intimate knowledge of the law. You don't have to have a long form justifying why you're appealing it. You just have to say, I am appealing it. So we're going to jump to the form a little bit and then come back to this. This is on our website. There's also a paper copy you can print out and scan or email if you'd like to. So super simple. Your name, all that sort of basic contact information. And then you have a little bit about which agency it is, all of that. You can write it in. And then all you have to say, this is really important, that top box, the records at issue. If you could go back, yeah, records at issue. If there are 10 records that you requested and you only want to appeal the denial of some of them, you have to outline them. And only the ones you list here will be the subject of the appeal. If you forget to list one of the records you were denied, it will not be considered in this appeal. So make sure that you include all of that. And then there's some basic information about how you communicated with the agency. And then the next slide, you can attach files. I'm going to talk about this more if you want. If you want to give an exhaustive history of what happened, if you want to give your legal argument, if you want to provide facts, you can, but you are welcome to leave that blank. But you do have to attach a lot of files, and that's listed below because this can be a procedural defect that throws out the appeal. You have to include your copy you made for the request of records, all of your original right to know requests. You have to include all responses from the agency regarding your request, any things about timeline where you extended it with the agency, basically all that paperwork. It's your job as the requester to do that, not the OOR's job or the agency's job to find those records and appeal them. You could also, like I said, attach other things here about what it is that why you think you should win the appeal. And then there are a couple other little forms. If you would kindly agree to giving the OR some more time, you can opt in right there. And another one, if you want to resolve this through mediation, that's another box you can check. That means instead of exchanging papers back and forth, you sit down via Teams and talk about the issues at hand. And sometimes, like anything in life, sitting and talking through things can be result in a lot more, have more results than just talking via email. So make sure you've attached all those things, you make sure you're not a robot, and you submit it. It's that simple.
But Liz, what if you are a robot? No, I'm sorry.
Then you're going to struggle. So going back, so you only need to complete the form. You can make the arguments later. You do not need an attorney. And then we will have an appeals officer assigned to your case. So there's an individual and an officer, one of our attorneys, who will work with you on this. Both sides can present evidence and arguments, and we have 30 calendar days to issue that final determination. Again, extensions are helpful as well. All right, so you've submitted the paperwork, you're on board to file this appeal. What happens? Well, it's similar to kind of an informal process. The agency is required to defend their reason for why they denied access to the record. Again, the burden is on them. It's not on you. You can just sit back and maybe answer some procedural questions, but you don't have to engage in that. They have to do that. It's to provide legal arguments and specific evidence. The law gives us the option of conducting a hearing, and that is extremely rare. As I've said before, we appreciate extensions. Some of these appeals, as we've developed a lot of precedents and other cases, they're very complicated and need research. We also, as I mentioned, have a very heavy workload. So it's helpful if we ask if you agree to that extension. It also can be beneficial to you if you want to be particularly involved in the case and you want to hack about briefings. You can put up a schedule and give time for the agency to respond. And then the next slide.
Do you mind, Liz, actually,
yeah,
do you mind if I just say one thing on this? When I am doing appeals, I always try to work out a staggered briefing schedule, which requires negotiating with the other side, and then also, of course, getting approval from the Office of Open Records Appeals Officer, so that I can say my piece, the agency can respond, and I can respond to that. And as a consequence, then that put, you have to agree to give OR more time to make a decision because you're taking more time to do the briefing. That's just one of the things I always try to do, and I think it works out well. And the intention is not necessarily to reduce OR's workload, but it's maybe it's a nice twofer.
Thank you. All right, so let's say you have either a lot of passion or a lot of knowledge of the issues at hand. What's helpful for you to help? It's not about emotions and feelings, but facts. If you want to talk about with specific court cases or previous final determinations about why you think you are unjustly denied access to a record. But it's all about specific evidence, facts, all of that. And one important thing on this is to have more bearing, submitting an affidavit rather than just saying, this is the way, this is what happened in terms of factual information to state that it's wrong. You can, if the agency cites or new additional reasons for denial, you can ask for an opportunity to respond. So this is completely optional, but just some tips if you do want to engage what is helpful in the appeal situation. Again, you do not need a lawyer. Absolutely not. Thousands of appeals are done every year, almost all of them done without an attorney. If you keep organized, keep careful track of the dates, again, the burden is on the agency to defend their position. You don't have to engage in legal or factual arguments. The reasons to do it, if it's really complicated or you just have the ability to outsource all of the organization of the dates, that's a nice thing to have. And all right, so what are your options? After the final determination, I apologize, I was using lingo without explaining, is what we call our decision. Whether or not it grants access to the records, overturns the agency, upholds their denial, or there's some combination of the two. If there's multiple records at hand, the final determination may grant access to some, deny others. There's two things you can do if you're not satisfied with what happens in that final determination. If you believe there's a technical thing, something was overlooked or an error, we have something called a petition for reconsideration within 15 days. You can't submit new evidence, but this is if you see, you believe there was something overlooked or a mistake made. So that's something you can do. The second thing, you can take it to court within 30 days. For local agencies, it's the Court of Common Pleas, state agencies, Commonwealth Court. And most recently, we've had, I think, less than 5% of our appeals end up in the courts. So it's not a ton of them, but they do certainly make their way through the courts. It does tend to take a while. There's some that are less than a year, but usually it's more than that unless the agency or the requester decides not to appeal it beyond the initial court appeals.
Liz, there's a question in the comments, and I also have a question for you.
Okay.
That I'm going to ask mine first because I didn't write it down. I don't want to forget it. So let's say that your requester, you win before the Office of Open Records, and then the agency just refuses to turn over the records. It's not that the agency doesn't take an appeal. They're just non-responsive and just don't give you the records. What's the course of action then?
Kyle, can you talk about that a little bit?
Sure. So the avenue for getting relief would be filing some sort of enforcement action with the court with jurisdiction. It differs a little bit depending on whether you're dealing with a local agency or Commonwealth agency. But essentially, like at its heart, you're going to be seeking a writ of mandamus from the court to direct the agency to comply with our final determination. If our final determination isn't appealed, it becomes a binding enforceable order, meaning that you can get essentially relief from the court to help enforce it. We unfortunately can't enforce our own final determinations. A court would have to do that.
And Kyle, what would be the timetable to do that? Because I guess you would have to wait until after the 30 days runs to see if the other side appeals.
Correct. Let's see. There is I'm not sure the timetable off the top of my head, but you do have a couple months. And there's if you're going to be filing in the Commonwealth Court, there's a rule of appellate procedure that governs the enforcing of an OR final determination. And it's a little bit different than the Commonwealth Court.
All right. Well, thank you for that. I realize that maybe is a bit of an edge case, but it is something that came up recently here at the ACLU. And so I was just thinking about it. And Liz and maybe Kyle, there's a question, up until what point can an agency come up with different reasons for denying access? So, at the initial agency level, they may have, reasons 1 and 2, but then if you appeal to the Office of Records, they may come up with 5 additional reasons why. Can they do that? And then if you end up in Commonwealth Court, can they come up with additional reasons at the Commonwealth Court level that they haven't raised prior in the proceedings?
Kyle, that's a good question for you.
So the courts have held that agencies can raise new grounds for denial before the Office of Open Records, and that will happen on occasion. However, the ability to raise new grounds for denial typically ends with us. Since we're the fact finder, essentially, there's also precedent saying that you can't raise new grounds for denial after you've presented everything to the initial fact finder, which is the Office of Open Records. So you wouldn't be able to go in front of the Commonwealth Court and raise new grounds for denial. You would have waived those grounds for denial as an agency.
Great, thank you. All right, so I think we're going over to Jess now.
Great. Thanks, Liz and Andrew, for your deep dive into background, key points in the right to know law, how to file a request, and how to appeal a denial. And thanks Nathaniel and Kyle for diligently answering some of these impromptu questions. In the last section of our presentation, I want to take you through 10 tips and best practices that we've learned from real practical experience from lawyers like Andrew and non-lawyers like myself. My colleagues and I at the ACLU of Pennsylvania, we filed dozens of right to know law requests. We've requested a variety of records from a variety of agencies, including local jails across Pennsylvania, police departments, school districts, the Department of Corrections. Whether it's for advocacy and holding government officials accountable, or litigation and developing facts for a class action lawsuit, we regularly avail ourselves of the right to know law. We reflected on our successes and some of the pitfalls we've encountered from crafting requests, litigating denials, and analyzing records. And we tried to distill 10 tips and best practices that have helped us file effective requests and ultimately obtain the records we're seeking in a promptly manner. And so we've ordered these tips by stages of the right to know law process. The first tip that I want to get into, brainstorm first and do your research. So before drafting the request, start by thinking through what you want to achieve. And here are some of the questions you should consider. What do you want to know? Sometimes the answer to that question is very clear-cut. Maybe you're trying to confirm or disconfirm a fact. Other times, though, you have a general idea of the issue, but your investigation is sort of open-ended. You don't know all the contours of the situation. We received a question in the chat recently about the racial breakdown of people held in a jail. Maybe you don't know the types of data that a local jail captures and maintains. That's okay. Sometimes your records request is sort of an exploratory investigation. The ACLU of Pennsylvania has been in both types of situations where we know certain types of records exist, we know what we want to know, and other times we're not as sure and the situation is a bit less clear. But figuring out what you want to know can help shape how you write the request. Another question, what kinds of records are you seeking? So for example, does the information come in the form of a spreadsheet, a contract, meeting minutes, email between local officials. The right to know law is expansive in that it covers a variety of records. And if you're seeking specific records, it can be helpful to define the type of document and help narrow the agency search. Like Andrew mentioned, some of these agency open records officers aren't 100% familiar with the inner workings of their own agency. Maybe they're overworked, they're underfunded, they're strapped for resources. Pointing them in the right direction in terms of the types of records you're seeking can be helpful. And next, who would have those records? Andrew mentioned earlier, addressing your request to the correct agency is essential. So if possible, do your research and figure out which agency possesses those records. In the criminal legal reform space, there are a variety of stakeholders who might possess the records you're looking for. It can be helpful to narrow down and identify the specific agency that has custody of the records you're looking for. Doing your research and brainstorming first can also be helpful because many records may already be public. So to avoid wasting your time, it can behoove you to look online, see if budgets, meeting minutes, annual reports, those types of records will often be published online and made publicly available already. And the last point I want to make is that brainstorming first and doing your research can help prepare you to fight a denial. So if you heard an elected official state X and that records relating to X surely exist, then you know that an agency's denial is likely mistaken. So we've experienced this several times where, for example, we've read in the news that governments contracted with a private company for the purposes of some governmental function, but the agency denies the request, saying that those records don't exist. Brainstorming first and doing your research positions you better to fight that denial because you know that the denial may be mistaken. So the more thought you give to your request, the better chances you have of obtaining records and obtaining them promptly without going back and forth with the agency, without protracted deadlines or even a long, drawn-out appeals process. So tip 2, specificity is key. Now that you've given some time to brainstorm, it's time to write the request. Andrew touched on this before in his section on how to file, but it's worth reiterating that your request has to be specific. One of the easiest ways for an agency to deny a request is to simply claim that the request is overly broad or vague. So in writing your request, keep in mind 3 things that Liz laid out for us here: subject matter, scope, and time frame. And this can be a bit abstract, so I thought it could be helpful to take a look at 2 examples that illustrate a request having subject, scope, and time frame. So here are 2 examples. The first example you see is a request we made regarding jail data, which may be of interest to some folks in the audience. Let me read that first example. The number of individuals who were held at the Blair County Prison as of the first day of the month for the past 12 months, September 2018 to September 2019. The breakdown of those total populations numbers by the number of individuals who are awaiting trial, who are already sentenced, and who were held for failure to pay child support or some other financial obligation. And the third request, a further breakdown of the number of people awaiting trial who are held on each of the following: detainers, a detention order, or an unpaid monetary condition of bail. So in this example, we have subject. We're asking for various jail data. It has scope and time frame. We've limited this jail data to a year's time, September 2018 to September 2019. And you can see that the request is pretty detailed. I know someone in the audience asked about racial data, and that's something you can simply ask, a breakdown of a racial breakdown of the people held in Blair County Prison as of the first day of the month for the past 12 months. Some of that information might also be in annual reports, so it can be worth coming at the request from different angles. But now let me read the second example. Any and all monthly or annual reports created by the Montgomery County Correctional Facility regarding statistics and or information on MCCF from January 1st, 2020 to the present. So this request is concise, much shorter than the first one. It's more, it's less defined, but that's okay. It still has subject, scope, and time frame. We're asking for records created by MCCF in a specific time frame regarding whatever types of information that they capture in the course of its daily operations. Great. So tip 3. In crafting your request, you also want to be aware of walking into the exemptions that Andrew laid out earlier and having your request denied. So try to anticipate which exemptions the agency might claim and figure out if you can work around them. And there are 2 exemptions I want to highlight and reiterate. The first being that the right to know law obligates agencies to produce records, only the records that exist. So an agency isn't required to create a new record in order to satisfy your request. The agency might have the information you're looking for, but the specific records that you requested in the specific format you requested them in, maybe that doesn't exist, and therefore your request can be denied. This comes into play especially with requesting lists of information. So oftentimes, like Andrew mentioned before already, lists of information don't exist. Agencies don't have to compile a list unless it's a database pull. So if the information you're looking for isn't aggregated in a list form, your request can be denied. So instead, ask for the responsive records that, when compiled, give you the information you're looking for. Just to drive this home, for example, we want to know all the bail bondsmen, a list of all the bail bondsmen in Pennsylvania. Rather than asking the Pennsylvania Insurance Department for a list of all bail bondsmen, we might ask for all certificates or other records relating to each bail bondsman currently registered in Pennsylvania. Sometimes you might get lucky, an agency will produce record that it doesn't have to in the spirit of openness and transparency, so it can be worth a shot. The second exemption we want to highlight is the Criminal History Record Information Act, also known as CRIA. Recently, agencies have invoked CRIA as an exemption in a number of our requests regarding criminal, in our work on criminal justice reform. So just to be aware that investigative records are exempt and tip 4.
Jess, can I interject for just 1 second to say that we have 15 minutes left and 7 tips to get through. So just make sure you keep your eye on the clock.
Thanks. I will pick it up. In writing your request, you're not limited to just describing the records. This 4th tip says, you can provide context and remind the agency of specific provisions in the right to know law. You can elaborate, and you can remind the agency open records officer of provisions in the law that they might not be super familiar with. So a couple things that you might want to explain. Delivering records electronically, especially since COVID, we've at the ACLU prefer receiving electronic records, but without specifying the format we prefer. Agencies have sent me paper hard copies to the office and even floppy disks through the mail. Right. You can also specify that you want the record in the original format that it's maintained in. So I've received, for jail data, for example, an agency has produced a table of data, but I wanted to see the database itself. I wanted to see the record in the original format, not reproduced in some table. You can explicitly say that in your request. Redactions. You can specify that you're not looking for investigative information that would be exempt. You're not looking for sensitive information. Government contractors. You can specify, you can remind the agency that governments who contract with a private company to perform some kind of governmental function, the agency is required to get those records from the private company because those are public. And that's something that they might not be super familiar with. And information and databases. That is also public, even if the agency doesn't have the technical finesse to pull that information for you. That information is public and they're required to produce it under the right to know law. And I want Liz to delve into databases a bit more before turning to tip 5.
Just wanted to reiterate with databases, they can be tricky in terms of what the agency says. My colleagues are on this call, so they may not like that I say this, but always consider appealing if you're not satisfied with what the response was, because agencies sometimes don't themselves understand that the data in the database is public information, even if it's complicated sometimes to pull it. And wanted to mention 2 really important resources to find some good information. The state agencies that have contracts of more than $5,000, in theory, should all be on an online database with the treasurer. And also PennWatch, if you don't know about this, it gives you all sorts of information about state employees, titles, salaries, counts, names broken out by agency, and some basic budget data. So there's some places to go before having to do a right to know request.
Thanks, Liz. So I'll go through the last 5 a bit quicker here. Tip 5, consider sending multiple requests simultaneously. And I mean this in 2 ways. One, it can be helpful to divide and conquer a request. If one of your requests is more vulnerable to an exemption or legal review, but your others are straightforward, non-controversial, it can be helpful to split those up to avoid having one of your requests slow down all the others. And the other way I mean this tip is that you might send the same request to multiple agencies at the same time if you're unsure which agency has the records. Maybe different agencies have this information in a piecemeal way. We recently sent a public records request to the police department. They, 5th business day, they asked for a 30-day extension. 30 days passed. They deny our request saying that this other agency possesses those records. So it was a long time to wait for that. Instead, it would have been wiser to send that request to multiple different agencies at the same time to avoid that protracted timeline. Next, tip 6. You sent the request. Now it's important to sort of track deadlines and stay organized. Andrew and Liz discussed an agency has 5 business days to respond to your request. But if they blow past that deadline, then the burden is on you to file an appeal. You might get multiple emails from different senders. Sometimes an agency will have an automatic reply from an email account that's not monitored. You want to keep track of any and all communication you receive to build a clear record for appeal. Also, in receiving records, we've in receiving records, an agency has sent us multiple email attachments. So you want to just, keep your eye on your inbox and be aware that you can receive multiple emails from different senders. Tip 7 here, engaging with the right to know law officer can be helpful. They can help understand your request, and by better understanding your request and the records you're looking for, that can help reduce your timeline. Tip 8. Sometimes an agency won't conduct a thorough search and simply deny the request. So don't be afraid of the appeals process. It might be the necessary push for the agency to make a good faith effort to search for those records. They can just, we recently filed a right to know request. The agency denied it, we appealed, and in the course of negotiations, they said, we do have some records, and it became clear that the agency didn't even attempt to look for those records before denying the request. Tip 9 here. Try to work out a briefing schedule with the appeals officer and agency. So OOR will set a date where both sides have to submit their briefs. So it's better, though, to work out a staggered briefing so sides are responding to each other instead of both sides submitting their briefs without really seeing or hearing the arguments from the other side. And finally, tip 10. Frustrating responses are not the end. So you sent your request, you did your research, maybe you went through a lengthy appeals process. Maybe there was a different way to phrase your request. Maybe it's a different format, maybe it's to a different agency. Maybe the information isn't collected, and that in itself is valuable information. Maybe the agency should have redacted portions of the records instead of denying the request outright. That's something that we encountered in our right to know request to Montgomery County. And finally, communicating with the agency officer and understanding the basis for denial. In a recent request, an agency officer told me, this information isn't collected at Lancaster County Prison. We recently got a new database that will help us collect this information, but for the time period you're looking for, we weren't onboarded to this new database and this information doesn't exist. Sometimes the agency officer will elaborate and provide further context in your records request. So those were the 10 tips and our presentation. I believe we have 5 minutes left for Q&A.
Oh my gosh, we've made it. And while we wait to see if anyone has any questions, some additional slides up here just in terms of some resources. One of the handouts that folks got are just for this presentation are just a copy of the PowerPoint slides, because Liz's crew at OR has for years, even dare I say predating Liz, has had really helpful guides up on the OR's website that there's no need for anyone to try to recreate. So if this presentation left you with more questions than answers, you can always go and check out that really helpful stuff. And also just want to say that there's some contact information up here. Please don't inundate me with specific questions about your right to know law situation, but my email is here in case you have anything that comes up. So Andre has asked a question. So appeals have dramatically increased, 48% over the past couple of years. Do you have any idea about what the number of requests to agencies are? Because probably most requests don't get appealed.
Yes, only about 3%. So based on that and just anecdotally what I'm hearing from agencies, is I would assume that that their right to know requests have increased by close to 50% at least, I would imagine.
There's a question about so I think we've used the word citizen, residents, other things. Yeah, I double checked the right to know request in respect to Laura's question, and the right to know request uses the term of art requester, as in a person who requests a document, and a requester has to be a legal resident of the United States. So there you have it. Although I will say that probably no one's checking, so you can keep that in mind. There's a question from Joseph, if Liz can handle that.
Yeah, we cannot give any, if the question is, can you talk to the OR before a request for guidance? Because it may become before us as appeal, we cannot give you legal advice, but we may be able to point you to relevant information that could help you. So the answer is it's certainly worth a shot, but we're not going to be able to write it for you or give you legal advice.
Great. Liz and Jess, nice job. High fives all around. Thank you, everyone, for attending.